Another tool that you can use in closing argument is to tie up the cross-examination. By the way, in conducting trials in court, as an attorney, you never want to ask a witness a question that you don't know the answer to already. Nor do you want to ever ask an opposing witness a question when you're asking them to elaborate or to go into detail. You want to limit very carefully. You don't want the witness to explain or to fill in gaps. You want to refrain from asking the ultimate question of the case. In other words, you don't want to ask them, was your client at fault? So, for example, in the firefighter case, a way that the prosecution could tie up the cross-examination would be to say, ladies and gentlemen of the jury, how do we know that the defendant was running late? He said it himself. Okay, that's an example as to how you could tie up cross-examination. Another tool would be to argue witness credibility and motive. In fact, closing argument is the only time in which you can directly confront character and explain why someone should not be believed. You can make those kinds of comparisons in closing, in other words, that you couldn't make in opening statement. And what I'm getting at is that, for example, in the firefighter case, the defendant is going to have a very strong motive to make up a story simply to get out of the property damage claim, or to simply avoid having to pay money in damages in the case. So for example, the prosecution could say, or the plaintiff could say, ladies and gentlemen, which is more likely? And then go on to make those kinds of comparisons. Another tool that can be used in closing argument is to assert weight that should be given to evidence. In the opening, just to contrast, in the opening statement, the attorneys present the expected evidence, the evidence that they think or are planning to have presented in court. In closing, the attorneys assert the weight of the evidence. The weight is the significance of the evidence. For example, in our playing cards, in closing, you want to highlight this is the ace of diamonds. This is a fact favorable to the defense. The defense attorney will want to highlight this case and explain to the jury why this fact has more weight or significance than other facts. In closing, it's also appropriate, and it's a powerful tool to comment on the opposing witness's demeanor in court. Demeanor is the way the witness comes across in court. Ladies and gentlemen, I want you to remember that when the defendant was testifying, he did not look at the jury, and he was unsure about the details, and he was inconsistent in his answers. He contradicted himself later on cross-examination. That's totally appropriate to point out the demeanor of the witness at closing argument. Another tool that can be used is to directly confront your weaknesses. As we mentioned, your story needs to account for all of the facts, even the bad facts. You can't hide facts in your pocket. But the way that you explain those facts is very important. And sometimes it is a wonderful strategy in closing to simply confront your weaknesses. One of my heroes in the law is Abraham Lincoln, who was a president of the United States during the American Civil War. He was also an attorney, a trial attorney, a very fine trial attorney, and practiced law from the 1840s through 1860. I have actually read many transcripts of his trials and accounts of his trials, and this was a common tool that Lincoln used, would be to frankly confront the weaknesses of his case. He was primarily a defense attorney. And he would go before the jury or the judge and say, "Judge, or ladies and gentlemen of the jury, we admit this, and we admit this." However, then he would come down strongly on his most powerful point and rest on his most powerful point. It can demonstrate to the jury your honesty and your fairness to confront your own weaknesses. A defense argument, for example, may be in relying on bad witnesses. For example, circumstantial evidence may be, in this case, in the firefighter case, may be very bad for the defendant. The circumstantial evidence is the fact that he had an appointment, that he was parked 2 blocks from his office, that he had 5 or 10 minutes to get there, and that he made the phone call afterwards. So in other words, the circumstantial evidence is that he was very distracted and that he was driving too fast and was more concerned about talking on the cell phone to his office than he was about the traffic. So that's one of the weaknesses that the defense is going to have to address. Another tool, this is 11 out of 13 tools of closing, would be to comment on promises kept or broken. When we make an opening statement, we are really promising the production of evidence to the jury.